The Spirit of the Common Law. Chapter 2, Puritanism and the Law. Legal history, as we now know it, began to be written after Savigny and so after Hegel. Hence the great man interpretation of history, which was superseded by Hegel's idealistic interpretation, has never played much part in the literature of law. The attributing of ancient codes to gods or to divinely inspired sages, or the Greek and Roman practice of attributing a whole body of legal and political institutions to some one lawgiver, are another matter. They represent an attempt to put symbolically the sacredness of the law or the antiquity and authority of the custom on which the general security rests, and their place is taken in modern times by an idea that our traditionally received body of law is based upon an eternal intrinsic reasonableness. Yet something might be said for a great lawyer interpretation of legal history. One might attribute progress in legal institutions and the development of legal doctrines to the influence and the genius of leaders among juristic writers, judges and practicing lawyers. Lord Campbell thought the lives of the chancellors and of the chief justices might be made to tell the history of the English Constitution and the history of English law. Not long ago a writer sought to give us the spirit of the classical Roman law through a study of the life and character of Papinian. Undoubtedly the great lawyer has not been the least factor in legal history. Roman law without Papinian and Ulpian and Paul. The civil law of the modern world without Bartolus. International law without Grotius, French law without Pothier, German law without Savigny, the common law without Coke, or American constitutional law without Marshall, are almost unthinkable. But it may be that lawyers are products of legal development, or along with legal institutions and systems and doctrines are results of deeper-seated forces. It may be that the lawyers themselves call for interpretation. Historical jurists in the last century were wont to teach us that the contents of a legal system were a necessary result of the whole history of a people and were no more to be explained by the labors of individuals than was language. Later it was asserted that great jurists and great judges had been but the mouthpieces through which social forces, or the civilization of the time and place, or class struggle or economic pressure and the interest of the dominant class for the time being, had spoken the law. Whichever of these views was accepted, the creative role of great lawyers was pushed into the background in legal history, and he would be a bold man today who would essay an exposition of the spirit of the common law by study of the judges through whose decisions our law has been expressed and has been given form. But little has been done in the way of applying the other modes of interpreting legal history to the history of Anglo-American law. The idealistic interpretation, which looks upon the history of law as the unfolding of an idea of right or justice in human experience, has been employed with no little success in writing the history of Roman law. One phase of this, the religious interpretation, which seeks the key to juristic progress and juridical institutions in the progress of religious thought and in the progress of religious institutions, has been used in connection with Roman law by those who have attempted to trace the effect of Christianity upon the final stage of that system in the ancient world. Neither of these, however, has been tried by historians of the common law. Another phase of the idealistic interpretation, on the other hand, has been the staple of our books in the immediate past. Both in jurisprudence and in politics, the political interpretation has been the favorite in England and in America. Historically it assumes that a movement from subjection to freedom, from status to contract, is the key to legal as well as to social development. Philosophically it sees the end of all law in liberty and conceives of jurisprudence as the science of civil liberty. Given currency in the United States through the writings of Sir Henry Maine, this interpretation was no mean influence in bringing about the attitude of our courts and lawyers toward social legislation, which often, but, as I think, erroneously, has been attributed to class interest. An ethnological interpretation, which finds the determining factors in juristic progress and in legal institutions in the characteristics of the races of men among whom laws exist, has been urged also. But the attempts to apply this method to the history of Roman law have yielded doubtful and meager results, and there seems no reason to suppose that it will do more for the history of our law. Finally, there is an economic interpretation which is much in vogue at present. Its exponents assert that the idea of justice has had nothing to do with the actual course of legal development, and contend that the sole agency in determining the growth and the content of legal systems has been the self-interest of the class dominant for the time being in a particular society. There is truth behind each of these several interpretations, and it would be hard to choose among them, if choice were necessary. But choice is not necessary. No social institution is the product of any one cause. It is rather the resultant of many causes, of which some observers will lay stress upon one and some upon others, but none of which may be left out of account. Hence if some tell us that the spirit of the common law, the exaggerated abstract individualism of our juristic thinking and judicial decision in the last century, is due to an innate tendency to individualism among Germanic peoples, kept down in some quarters by the weight of Roman authority, but never so repressed in England, while others see in it an outgrowth of the political contests between the courts and the crown in the 16th and 17th centuries and an outcome of the political development of that time. If some regard it as a product of Puritanism, an application of Puritan ideas in law and politics, reaching its highest development in America, that paradise of the Philistines, as Matthew Arnold put it, while others see instead a result of economic thought and economic conditions in 19th century America and of the frontier spirit surviving the frontier, I do not think we are bound to make an absolute choice. In truth, all of these are factors, and more than one has been a factor of importance. Possibly one might refer Puritan theology in 16th and 17th century political thought ultimately to Germanic individualism. Kept back by Roman authority in law and in theology, the Germanic genius burst its bonds at the Reformation, and the individual asserted himself in law, in politics, in philosophy and in religion. One might say that there was something congenial to the Germanic spirit in Hebraism which gave the Old Testament so profound an influence when our fathers began to read it. In that view, the Germanic character plus the economic conditions of the past century and the resulting economic theories would be our formula. But one must reckon with the interaction of individualist character and religious doctrine and social conditions upon one another. There is little to be gained therefore by an attempt at broad generalization. We may say, at least, that Puritanism of itself, and possibly because of the deeper-seated causes of which it was a manifestation, has been a significant factor in molding the spirit of our common law. Indeed, there are special reasons for believing that Puritanism has been in a sense a controlling factor. And these reasons are my excuse, at a time when religious interpretations are not the fashion, for venturing a bit of religious interpretation of jurisprudence. For individualism, in and of itself, has not been peculiarly English or peculiarly American. What is peculiar to Anglo-American legal thinking, and above all to American legal thinking, is an ultra-individualism, an uncompromising insistence upon individual interests and individual property as the focal point of jurisprudence. Other causes brought about a period of individualism in jurisprudence, in politics and in economics everywhere. It was perhaps Puritanism which gave that added emphasis to individualist ideas in the formative period of our American legal thought that served to stamp them upon our theory and our practice and kept them alive and active in the United States a half-century after English legal thought had turned over a new leaf. Upon this hypothesis, the religious interpretation of our legal thought becomes no less important than the philosophical interpretation of Roman law, through recognition of the part played by the Stoic philosophy in its formative period. Individualism in legal science, as distinguished from law, had its origin in the end of the 16th century and beginning of the 17th century in the rise of theories of natural rights out of the older theories of natural law. Two main factors in this rise of individualism may be recognized, namely, the emancipation of the middle class and Protestantism. Alzheimer has identified the former with the maturity and decay of the theory of natural law. But individualist natural law still flourishes in America. And if it be said that America has been par excellence the country of the middle class, we must note that the middle class has been dominant elsewhere and that Puritanism has given a peculiar character to the middle class of England and America. Even less may we attribute our common law mode of thought solely to the Protestantism of England in the period which was decisive for modern law. For one thing, its attitude toward the state is quite as much Catholic as Protestant. It is much nearer the view of the Jesuit jurists of the Counter-Reformation than it is to the view of Luther and his followers. In politics, Luther's principle was passive obedience, holding that submission to civil government was enjoined upon Christians by the Scriptures, Both Luther and Melanchthon vigorously denounced the Anabaptists and the rebellious peasants. Indeed, they assumed that the state was a chief good and that no individual claims could stand against it. The basis for this doctrine was nationalist rather than individualist. They insisted on the local sovereign as against the universal church, and the Protestant jurist theologians who followed them insisted upon the national law proceeding from that sovereign as against the universal authority of Rome. Granting that it was the mission of the Reformation to give life to individual freedom through the state and through society were quite as possible means of achieving this mission as the Anglo-American exaltation of abstract individual freedom above the state and above society. In other words, a peculiar phase of the emancipation of the middle class and a peculiar phase of Protestantism must be taken account of in order to understand the spirit of our common law. It is not an accident that the first reformer in English legal thought was also the first reformer in English religious thought. John Wycliffe is known for his resistance to authority in the church and his translation of the scriptures to bring them home to the common man. But in his tract De Officio Regis he attacked authority in law and asserted the sufficiency of English case law, for such it fairly had become, against the venerable legislation of Justinian and the sacred decretals of the popes. Let us remember what this meant according to the theories of that time. Whatever the fact, the theory of the king's judges was that they administered the common custom of England, the customary modes of action of Englishmen in their relations with each other. The academic theory as to the Roman law was that the corpus juris civilis, as legislation of the Emperor Justinian, was binding upon peoples whose rulers were taken to be successors of Augustus. The theory as to the canon law was that all jurisdiction was divided between the spiritual and the temporal, that in matters spiritual the temporal authority was wholly incompetent, and that the Church, whose mouthpiece was the Pope, had an absolute legislative power within this field. The Pope, says Boniface VIII in the 14th century, holds all laws in his breast. Wycliffe said boldly that men might well be saved though many laws of the Pope had never been spoken, that Roman law was heathen men's law, and that there was no more reason and justice in the civil law of Rome than in the civil law of England. He appealed from authority to the local custom of England, from the rules imposed externally by Roman law and the Pope, to the rules which Englishmen made for themselves by their everyday conduct. But this was the same position which Wycliffe took with respect to religion. In law and in religion he appealed to the individual and for the individual against authority. But the real influence of religious thinking was to come later. It has been said that for most purposes the history of the common law begins in the latter part of the 13th century. Indeed, it might well be said that for American purposes its history begins still later, and that we shall not err greatly in beginning with the end of the 16th century. I am speaking here of the common law as a mode of thought. Some dogmas, especially in the law of property, have a longer history, and our judicial institutions must be studied from the time of Henry II. But our attitude toward legal problems, our modes of legal reasoning, the principles which make up the system of the common law, have only to be studied from the reign of Elizabeth, and have a continuous and consistent development from that time. The periods of development in Anglo-American law begin respectively with the reigns of Elizabeth and James I, with the American Revolution and with the Civil War. What had been achieved in the English courts prior to Coke was summed up for us and handed down to us by that indefatigable lawyer in a form which the past generation chose to consider authoritative, and we have looked at it through his spectacles ever since. Hence the period of growth prior to the reigns of Elizabeth and James I but gave the materials. The shape which those materials have taken in the present law is due to the way in which their possibilities appealed to the end of the 16th century and beginning of the 17th century, to the interpretation put on them by Coke and his contemporaries, and to the subsequent working over of the product in America when we received such part of the common law as was applicable to the New World. Again, we may pass over the constructive work of the 18th century, for that work was done in equity and the law merchant. Neither of these strictly is part of the common law, and so far from their affecting the spirit of the common law, the spirit of the common law affects them powerfully. But there are two growing periods of our common law system, two periods in which rules and doctrines were formative, in which our authorities summed up the past for us and gave us principles for the future. These periods are, 1. The classical common law period, the end of the 16th and beginning of the 17th century, and, 2. The period that someday, when the history of the common law as a law of the world comes to be written, will be regarded as no less classical than the first. The period of legal development in the United States that came to an end with the Civil War. In the one the task was to go over the decisions and legislation of the past and make a system for the future. In the other the task was to examine the whole body of English case law with reference to what was applicable to the facts of life in America and what was not. Obviously the spirit of these times and of the men of these times whose juristic labors gave us the mode of treating legal problems which we call the common law, could not fail to give color to the whole system. But the age of Coke was the age of the Puritan in England, and the period that ends with our Civil War was the age of the Puritan in America. We must not forget that the Puritan had his own way in America, that he was in the majority, that he had no powerful establishment to contend with, and that he made institutions to his own liking. For, again, it is not an accident that common law principles, as they were fashioned in the age of Coke, have attained their highest and most complete logical development in America, and that in this respect we are and long have been more thoroughly a common law country than England herself. A fundamental proposition from which the Puritan proceeded was the doctrine of the willing covenant of conscious faith made by the individual. Thus he put individual conscience and individual judgment in the first place. No authority might rightfully coerce them, but everyone must assume and abide the consequences of the choice he made. Applied to church polity, it led to a regime of consociation but not subordination. "We are not over one another," said Robinson, "but with one another." Hence even church organization was a species of contract and a legal theory, a legalism, attached even to religion. If men were to be free to act according to their consciences and to contract with others for consociation in congregations, it was a necessary consequence that the state, as a political congregation, was a matter of contract also, and liberty of contract was a further necessary deduction. The early history of New England furnishes abundant applications of the idea that covenant or compact, the consent of every individual to the formation and to the continuance of the community, was the basis of all communities, political as well as religious. The precedent of the covenant which made Abraham and the children of Israel the people of God, furnished the religious basis for the doctrine. But it was applied to civil as well as to ecclesiastical organization. One consequence was to make for the individualistic conception that all legal consequences depend upon some exertion of the will, as against the feudal conception of referring them to some relation. Contract and voluntary culpable conduct appeared to be the solving ideas for all problems, and the law was to be apportioned between the contractual and the delictual. Another consequence was to make a moral question of everything, and yet in such a way as to make it a legal question. For moral principles are of individual and relative application. In applying them we must take account of circumstances and of individuals. Hence if every question was treated as a moral question and controversies involving moral questions were to be dealt with as concrete cases to be individualized in their solution, subordination of those whose cases were decided to those who had the power of weighing the circumstances of the actual case and individualizing the principle to meet the case might result. The idea of consociation demanded that a fixed, absolute, universal rule, which the individual had contracted to abide, be resorted to, and thus the moral and the legal principle were to be applied in the same way, and that the legal way. "Nowhere," says Morley, "has Puritanism done us more harm than in this, leading us to take all breadth and color and diversity and fine discrimination out of our judgments of men, reducing them to thin, narrow and superficial pronouncements upon the letter of their morality or the precise conformity of their opinions to accepted standards of truth." The good side of all this we know well. On the side of politics, the conception of the people not as a mass but as an aggregate of individuals, the precise ascription of rights to each of these individuals, the evolution of the legal rights of Englishmen into the natural rights of man, have their immediate origin in the religious phase of the Puritan Revolution. But on the side of law, it has given us the conception of abstract liberty of contract, which has been the bane of all social legislation, the rooted objection to all power of equitable application of rules to concrete cases that has produced a decadence of equity in our state courts, the insistence upon and faith in the mere machinery of justice, which so often makes American legal procedure intolerable in the business world of today, The notion of punishing the vicious will and the necessary connection between wrongdoing and retribution, which makes it so difficult for our criminal law to deal with antisocial actions and to adjust itself in its application to the exigencies of concrete criminality. How does this Puritan individualism affect the actual administration of justice? We may best answer by turning to each of the great departments of law and seeing the Puritan there at work. The mission of the Reformation, says Pirolzheimer, was to give life to individual freedom. In this the Puritan is the incarnation of the Reformation. Individual freedom of interpretation, individual free association, individual rights were the basis of his religious, political and legal views. But abstract individual free self-assertion and individual interests are by no means all that legal systems have to look to, and in the 19th century our law showed on every side the ill effects of taking these for the sole basis. For instance, few doctrines of the common law create more impatience with courts today than the traditional attitude toward legislation, the judicial assumption that legislatures are in what Dicey calls the quiescent stage, the professional feeling that there ought to be little or no legislation on legal subjects, the attitude of resentment toward legislation on the part of bench and bar that has led so often to the failure of legislative attempts to simplify procedure, and has made so much of the labor of social workers nugatory after they have put it upon our statute books. For many years a favorite topic of presidential addresses before the American Bar Association was the plethora of legislature-made laws. A late leader of the American Bar died in the harness writing an elaborate argument against legislation, and made generous provision in his will for a professorship in a law school whose incumbent should teach, I had almost said preach, the gospel of the futility of legislation. There is more than one reason for the attitude of the common law toward legislation, but not the least is the dominance of the Puritan during the formative periods of our law. His reasons were primarily religious. It appeared to him, says Lord Acton, that governments and institutions are made to pass away like things of earth, whilst souls are immortal, that there is no more proportion between liberty and power than between eternity and time, that, therefore, the sphere of enforced command ought to be restricted within fixed limits, and that which had been done by authority and outward discipline and organized violence, should be attempted by division of power and committed to the intellect and the conscience of free men. Such views of law-making fitted into and confirmed common law ideas which grew up in an age of legislative quiescence and were fostered by the masterful temperament of Edward Coke, who, brooking no lay interference with the law he had dug laboriously from the parchments of the past, impressed his ideas upon the tradition of which he was the authoritative exponent. Hence, the orthodox tradition of our law schools wholly ignores the reenacted element in law. In its teaching, the older element, represented by the traditional course of decision, stands for the real law and furnishes principles and analogies, while the newer element, represented by legislation, is regarded as something alien, intruding in the body of the law, and may furnish only detailed rules for the cases expressly covered. Yet, while confirming the lawyer in his attitude toward legislation, the Puritan was a firm believer in enactment. The Commonwealth in England brought forth a great outburst of legislative activity. One of the first fruits of Massachusetts was an attempt to set the statute book in order. This colonial code of statute law antedates the revision of English legislation some 200 years, and its preface contains a defense of legislative lawmaking. For, if the Puritan did not believe in coercion, he did believe in instruction, and liberal instruction through the statute book, with the extent to which the instruction shall be followed left largely to the conscience and judgment of the individual, has long been an unhappy feature of our polity. In the law of torts, few doctrines have been more irritating than those of assumption of risk and contributory negligence, as applied to injuries to employees. But these are eminently Puritan conceptions. The employee is a free man, guided by his own conscience and his own interpretation of Scripture. He chooses for himself. So choosing, he elects to work in a dangerous employment in which he runs a risk of being injured. He knows that others are to be employed with him. He knows that they may be negligent and that if they are, he may be injured. Very well, he is a free man. Let him bear the loss. The master has done no wrong. The servant, to use Mr. Carter's language, must stand or fall by the consequences of his own conduct. It is not an accident that the classical exposition of this doctrine was penned in Massachusetts. Again, a workman, engaged constantly upon a machine, so that he comes to be a part of it and to operate mechanically himself, omits a precaution and is injured. The common law says to him, "You are a free man, you have a mind and are capable of using it, you chose freely to do a dangerous thing and were injured, you must abide the consequences." As a matter of fact, it may well be he did not and could not choose freely. Before the days of workman's compensation, it was said that statistics showed the great majority of industrial accidents happened in the last working hour of the day, when the faculties were numbed and the operative had ceased to be the free agent which our theory contemplated. But there was no escape from the legal theory. That very condition was a risk of the employment, and was assumed by the laborer. Legislation has been changing these rules, yet courts long had a tendency to read the doctrine of contributory negligence into statutes even where the legislature had tried to get rid of it. Out of many examples in constitutional law, we may notice the 19th century decisions as to the right to pursue a lawful calling and liberty of contract, which bore so grievously upon social legislation until well into the present century. Here it is significant that the prophet of a belated individualist crusade, the late Mr. Justice Field, had added to a Puritan ancestry and Puritan bringing up, careful study of the common law and practice of his profession on the frontier at a time and in a place where the individual counted for more and the law for less than has been usual even on the frontier. No doubt the latter circumstance had its influence. None the less the conception of a maximum of abstract individual self-assertion exempt from social control, to which his vigorous and learned opinions gave currency, is essentially the Puritan conception of consociation. We are to be with one another but not over one another. The whole is to have no right of control over the individual beyond the minimum necessary to keep the peace. Everything else is to be left to the free contract of a free man. Happily this idea passed its meridian in our constitutional law at the end of the last century. Again, in criminal law, one of the problems is the individualization of punishment, the adjusting of our penal system to the criminal rather than to the abstract crime. Another is to get rid of the retributive theory, the revenge idea as the basis of legal treatment of crime, an idea which is the bane of punitive justice. Still another is to make the criminal law an effective agency for repressing antisocial actions and protecting society. At each of these points our Puritan common law theories have been fighting a vigorous defense and slow retreat. The Puritan's objection to individualization in punitive justice was instinctive and deep-seated, for he saw in the Star Chamber the same fundamental theory as that involved in the penitential system of the Roman Church. Sociologists are now recognizing the deep and humane insight of the ecclesiastical law and its essentially modern point of view. In the penitential system, it is not the crime, says Sales, but the criminal alone that is regarded. It becomes a subjective individualization under cover of a wholly objective legal sentence, and this is what we now demand. This subjective individualization, he continues, is the same formula which is called for today. To the Puritan, such a point of view was wholly repugnant. The same attitude toward law and government that called for an over-individualism in the abstract rules of law and in the doctrines from which they proceed, precluded individualization or adjustment to individual cases in the application of the rules and doctrines in practice. In the former it is an assertion of the individual against his fellows individually. It expresses the feeling of the self-reliant man that he is to make his own bargains and determine upon his own acts and control his own property, accepting the responsibility that goes with such power, subjecting himself to liability for the consequences of his free choice, but exempt from interference in making his choice. In the latter it is an assertion of the individual against his fellows collectively. It expresses the feeling of the same self-reliant man that neither the state nor its representative, the magistrate, is competent to judge him better than his own conscience, that he is not to be judged by the discretion of men, but by the inflexible rule of the strict law. Our criminal law had a new birth in the 17th century, when the fall of the Star Chamber threw the whole subject of punitive justice into the common law courts. Accordingly it received the Puritan stamp while it was formative, and in the 19th century many of the United States carried the Puritan repugnance to all margin of judicial action so far as to abolish common law misdemeanors and try to prescribe chapter and verse of a criminal code for every case. All three of the demands of modern criminal science, then, have been resisted by our Puritan criminal law. It is not so long ago that a learned Supreme Court released a child from a reformatory on the ground that a reformatory was a prison, that commitment thereto was necessarily punishment or crime, and hence could only be warranted by criminal proceedings of a formal type, conducted with due regard to constitutional safeguards. The rise of juvenile courts has accustomed us to courts of criminal equity for the youthful offender, but attempts to introduce any system of judicial individualization for the adult will have to wrestle a long time with constitutional difficulties. Indeed, we have had to resort to administrative boards and commissions to do what England now does through a court of criminal appeal. So, too, the retributive theory is among the fundamenta of our criminal law. The common law looks upon the criminal in the abstract. He is a free man, who, having a choice between right and wrong, voluntarily chose the wrong and must abide the penal consequences appointed in advance. Not only does this Puritan view of the matter keep alive the retributive theory in jurisprudence, after kindred sciences have abandoned it, but it hampers the efficiency of penal legislation intended to protect society. The good sense of courts has introduced a doctrine of acting at one's peril with respect to statutory crimes which expresses the needs of society. Such statutes are not meant to punish the vicious will but to put pressure upon the thoughtless and inefficient to do their whole duty in the interest of public health or safety or morals. Nevertheless, all extension of this doctrine has been opposed sturdily by our text writers, and to the Puritanism of Bishop and common law orthodoxy of Judge MacLean the decisions are anomalous and unsatisfactory. In the law of property we may see conspicuous examples in the doctrine as to abusive exercise of rights, as to use of property or exercise of powers incident to property for the sole purpose of injuring another, and in the older doctrine with respect to surface water. Here again we may note that the typical exposition of the extreme individualist view as to the rights of adjoining owners in disposing of surface water came from Massachusetts. Much of this has been done away with under modern Roman influence. But the common law asked simply, was the defendant acting on his own land and committing no nuisance? If so, it cared nothing about his motive. If one were to put the argument of the French jurists, that use of property merely to injure another is antisocial and should be repressed, the common law lawyer would no doubt reply in the language of Blackstone, the public good is in nothing more essentially interested than in the protection of every individual's private rights. Equity in America shows the same influence. The Puritan has always been a consistent and thoroughgoing opponent of equity. It runs counter to all his ideas. For one thing, it helps fools who have made bad bargains, whereas he believes that fools should be allowed and required to act freely and then be held for the consequences of their folly. For another thing, it acts directly upon the person. It coerces the individual free will. It acts preventively, instead of permitting free action and imposing after the event the penalty assented to in advance. For still another, it involves discretion in its application to actual cases, and that, in the Puritan view, means superiority in the magistrate in that it allows him to judge another by a personal standard instead of by an unyielding, impersonal, legal rule. Hence in large part the opposition to the Court of Chancery in England, which lasted almost to the 18th century, the abolition of the Court of Chancery by Barebones Parliament and the tracts against Chancery during the Commonwealth. Hence the reluctance of Massachusetts to grant equity powers to the courts and the popular vote against equity in New Hampshire after the Revolution. Hence the general tendency in the United States to turn the liberal doctrines of equity as to discretion in granting relief into hard and fast jurisdictional rules. Pomeroy has remarked the extreme reluctance of American courts to extend the jurisdiction of equity, even where such extension consists solely in applying familiar principles to new conditions of fact. The gradual abandonment of equity powers and legalizing of equitable doctrines, which I have ventured on another occasion to call a decadence of equity in America, is no less remarkable. Truly the methods and doctrines of equity have not been congenial to our tribunals, And if we remember that the latter have been manned with Puritans, the reason is obvious. From the beginning the Protestant tradition in law has been nationalist. The Protestant jurist theologians of the 16th and 17th centuries opposed a nationalist conception to the universal authority of the canon law and the universal doctrines of the Jesuit jurists of the Counter-Reformation. For universal authority, they sought to substitute the civil law of each people, sacred because it sprang from the divinely ordained state. The Puritan carried this particularism in law to the extreme because of his conception of states as political congregations. The Ten Commandments and the Scriptures, interpreted by the individual Christian, furnished sufficient general principles. For the rest, there was need only of the local laws to which those subject thereto had freely assented. Much of this spirit is with us today in the American exaltation of local peculiarities in law, in our fostering of local anomalies of substantive law and of procedure as if they had some intrinsic importance in the administration of justice to compensate for the manifold inconveniences to which they give rise. Until the general adoption of the negotiable instruments law, it used to be a saying in the West that a draft on Chicago drawn in Omaha and put through the usual course of collection was subject to 3 different laws. Nor did this seem incongruous to lawyers. Even now that, under pressure from businessmen, the uniform negotiable instruments law has been put in force, so little does the common law lawyer value universality, that there are disquieting symptoms of provincial interpretations in the several states which will involve a gradual return to our former condition of divergent local laws. It is, however, in application and administration of the law that Puritanism has produced the most serious results for the legal system of today. The Puritanesque characteristic jealousy of the magistrate has taken an extreme form and has been developed as a jealousy of the judge. There is, says Bryce, a hearty Puritanism in the view of human nature which pervades the Constitution. It is the work of men who believed in original sin, and were resolved to leave open for transgressors no door which they could possibly shut. It is hardly too much to say that the Puritan ideal state was a permanent deadlock where the individual, instructed by a multitude of rules but not coerced, had free play for the dictates of his own reason and conscience. For our legislation exhibits an inconsistency that is part of the Puritan character. He rebelled against control of his will by state or magistrate, yet he loved to lay down rules, since he realized the intrinsic sinfulness of human nature. Accordingly we have abundance of rules and no adequate provision for carrying them out. Until we began to find a way out by our recent development of administrative boards and commissions, law paralyzed administration. In the 19th century injunctions, actions of trespass, and mandamus proceedings hemmed in the executive officer on every side. But when the judicial department came forward to execute laws, local juries and grand juries, local prosecuting officers, local sheriffs, were given power to hold up as well as to uphold the law and wielded it as their individual consciences might dictate. Hence it was no less true that administration paralyzed law. The system of checks and balances produced a perfect balance. In practical result, the law too often accomplished little or nothing. We had abundance of law in the books, but very little law in action. Revolt from this condition, which had become intolerable in our complex urban societies at the end of the last century, has almost threatened a season of Oriental justice through conferring of wide powers upon boards and commissions which are expected to proceed with a minimum of rule and a maximum of expedition. Puritan jealousy of the magistrate is even more conspicuous in American judicial procedure. It has cooperated with the pioneer spirit and the ideas of rural communities in the first half of the 19th century to produce a condition in the administration of judicial business very like that to which it led in executive administration. In more than one state codes and practice acts aim to regulate every act of the judge from the time he enters the courtroom. It is hardly too much to say that the ideal judge is conceived as a pure machine. Being a human machine and in consequence tainted with original sin, he must be allowed no scope for free action. Hard and fast rules of evidence and strict review of every detail of practice by a series of reviewing tribunals are necessary to keep him in check. In many states he may not charge the jury in any effective manner, he must rule upon and submit or reject written requests for academically phrased propositions of abstract law. he must not commit any error which might possibly prejudice a party to the cause, whether in fact there is prejudice or not. The past 2 decades have seen a steady movement away from this type of procedure, but in more than one Western community, settled from New England, which preserves the pristine faith, it is dying hard. Dunning has pointed out that in America the Puritan was able to carry into effect what in England could be only abstract opinions. Hence in America, in addition to a ritual of justice belonging to a past age of formalism that put gold lace and red coats on the picket line, we have a machinery of justice devised to keep down the judicial personality which has made legal procedure in some sort an end in itself. At the beginning of the present century it had become evident that our legal system must temper its individualism, that the common law could not succeed in an attempt to force the modern world into a Puritan bed of procrusts. We may grant that the law should only temper, not abandon, the element in our tradition which was contributed by the Puritan. In another connection I shall try to show how we may use that element in the legal development of the future. But for the moment we must insist upon keeping it within bounds. If we recognize that it is not fundamental principles of jurisprudence, but traditional principles of Puritanism, operating out of their sphere, with which American legislatures are struggling, we may abate some of our hostility to legislation, and may be willing to allow lawmakers to take account of the demands involved in social life and formulate in laws the needs of crowded urban industrial communities even in derogation of our traditional law. We may be willing to concede something to the verbonus upon the woolsack who would protect men from themselves. We may be willing to allow the magistrate some power of meeting the exigencies of justice in concrete cases. We may be willing to trust a trial judge to use honestly and impartially the discretion without which trials will always be dilatory, expensive, and unsatisfactory. For it is always to be remembered that justice is made up of individual cases. If the judicial machinery does not produce speedy, inexpensive and just results in the actual causes that pass through it, no amount of mechanical or theoretical perfection will atone. Above all, we may be willing to relegate procedure to its proper place in the legal system. At the Battle of Balaclava the English pickets posted to warn their comrades of the approach of the enemy were themselves surprised, and the attack of the Russians on the main body was in progress before the pickets were aware that an enemy was in the neighborhood. In commenting on this, a military historian says that the surprise resulted from the high degree of drill and discipline of the pickets, which had destroyed all initiative and had led them to believe that they had done their whole duty when they had conformed to the rules in which they had been trained while on guard in barracks and parade grounds. The historian adds that rules may deaden men's wits but can hardly sharpen them. Legal formulas are necessary to preserve the dignity of the tribunal, to expedite its business, to keep the person of the magistrate in due bounds, and to give to the judge the benefit of the experience of the past. But they are means, not ends. However much it may have suited the Puritan disposition to make them ends, in order to bring about a maximum of individual self-assertion and a minimum of magisterial action, it is against the genius of the time and the interest of the modern industrial community to continue in this attitude.